All right, the defendant is present at this time. All right. And how does the state and defense wish to proceed?
Well, what we did was we put it here to get copies of the PSI and the PDR. Did Your Honor receive both of those?
Yes.
Okay.
Will there be additional evidence presented by either side?
No additional evidence, Your Honor, moving additional documents.
Okay, how about the state?
Not for the state, just us.
All right. So let me just make sure I have what I should have. I see Officer Curran prepared a pre-sentence investigation. And I believe I also saw a second document. Was there an additional document filed?
There should be a predisposition report, Your Honor, it's done by Maxwell T.
Okay. That I am not finding.
If Your Honor could actually look in case 19 CJ 516, I think that's what it was.
Does Madam Clerk have the ability to generate a copy of that? How lengthy is it, Mr. Rose? And what's the case number again?
19 CJ 516.
So it was not filed in this case?
It was not.
Okay.
And what am I looking for?
PDR.
The PDR?
And how do you say the last name? Do you say it Arevalo or Arevalo?
Arevalo.
Arevalo. Okay, Ms. Cunningham was correct.
That's not usually
Okay.
the case.
I'm wrong again. Wow. Now, just to recap, while she's looking for that, I did have testimony presented by Dr. Brooke Ferris previously at the hearing.
Yes, Your Honor.
And she was extensively cross-examined by Mr. Maresca. One might say aggressively cross-examined. We also had the testimony of Ms. Monica Chimal.
Yes.
Okay, so that's Mr. Arevalo's mother. That was briefer. And there's no additional evidence from either side?
No, Your Honor.
All right. And does the state wish to lead off or defer to the defense?
Judge, I'm happy to lead off, I guess. Just to clarify where we are, because I am stepping in for Mr. Maresca for his midstream. At this point, are you asking for our arguments and recommendations in regard to sentencing?
Yes.
Correct.
Okay, at this time, we're aware of the defendant's young age. The victim in this case was also extremely young. She was 8 years old. Based on the evidence in the case, this was not a one-time occurrence. Although the defendant is charged with 1 count. We have concerns because at the time that this incident happened, the victim's mother happened to walk in on the victim and the defendant. And we would ask that the court take judicial notice of the court file if that wasn't done at the time of the testimony that was taken in the last hearing.
Any objection?
No, Your Honor.
Granted.
And specifically within the affidavit and the booking sheets that the mother had walked in on the victim or defendant, both were unclothed from the waist down. Given the concerns and the fact that the defendant was actually applying to the observation at the time that this incident took place, the state is asking for that he not be given juvenile sanctions. We don't feel that given the facts of the case, even though he is of young age, that would be appropriate. And he has been afforded the opportunity to take part and to take advantage of the options available to him in the juvenile justice system, and that he continues to reoffend. He's forced to a minimum of 51.45 months in Florida State Prison for the score sheet. According to the PSI, the Department of Corrections is actually recommending 10 years in prison, followed by 5 years of sex offender probation. In speaking with Mr. Marasco, who had the opportunity to discuss the case with the victim's family, the state will be asking for 8 years in prison, followed by 5 years of sex offender probation with a GPS monitor. We would ask for an order of no contact with the victim. I understand, obviously, this is somewhat of a unique situation in that normally we would ask for no contact with the victim's immediate family, but given the fact that the defendant's mother is also the mother of the victim, we're not asking for that at this point. And we'd ask for the costs associated with the case, including the cost of prosecution and the cost of investigation to the sheriff's office.
Do we know what those amounts are?
I do not, I can just come more.
What are the court costs, Madam Clerk? Any public defender charges, Mr. Barger?
1 month. Your Honor.
The cost of investigation, Your Honor, is to the sheriff's office, and it is $833.
Waiting court costs and public defender.
Court cost is $566, Sheriff.
And are you able to determine at this time, Mr. Barger, what the public defender charges are?
1 month. Your Honor. Let me just see about it. We would ask for $7,205.
How much?
$7,205.
A large portion of that is expert fees.
It is, Your Honor. Yes, that's $6,955.
Does Mr. Arevalo wish to have a hearing and dispute any of the monetary amounts?
No, Your Honor.
Any additional state comments?
Yes, Your Honor. In conclusion, I know Your Honor heard the testimony from the experts at the last hearing. Although the defendant may benefit from sex offender counseling or sex offender therapy, that obviously would be something that he would complete on sex offender probation. And rehabilitation is always something that the criminal justice system looks toward. But we also have to look at the punishment for the crime as well, and the danger to the community. The fact that this was a little girl who was 8 years old, the defendant, although young, was 17. We're not talking someone the same age, we're not even talking someone who was 14. We're talking someone who was, for all intents and purposes, an adult. And so based on that, Judge, the state would ask for the 8 years in prison, followed by the 5 years of sex offender probation with GPS monitoring. He does not qualify to be a predator based on this charge, although the victim is under 12. He would be, however, sex offender.
Does the state oppose any youthful offender disposition?
Based on the facts and circumstances of this case, we would, Judge. Based upon my review of the police chief's affidavit as well as the materials in this case, quite frankly, the state could have filed charges in regard to an actual sexual battery of union with the defendant's penis with the victim's anus or vagina. And we chose not to. We gave the defendant that benefit, and he obviously pled to lose his molestation.
Mr. Barger, defense argument?
Yes, Your Honor. Under 985.565, there are, essentially several ways that we can go about sentencing Mr. Arevalo. There are the juvenile sanctions, there are the youthful offender, and then there are the adult. Prior to this incident, Mr. Arevalo had 2 juvenile cases. Over the time, one was downcharged to a battery, the other was a battery and a criminal mischief, which he was placed on probation for. Then the new charge came through. What we would be asking for, Your Honor, is juvenile.
So at the time of this offense, Mr. Barger, Mr. Arevalo was on juvenile probation for criminal mischief, and what was the other one?
And battery. Your Honor, he was 17 years old. He did not have a father in the home. He had a stepfather, which was abusive to his mother, and all this can be found in the various reports. What we would be asking for is a maximum risk program. And in that maximum risk program, he can receive sex offender help, he can receive counseling. There's one program in the Everglades Youth Academy, which is sentenced to, or as a maximum risk or a high risk. They can keep him as late as age 21. On August 14th of 2019, when he was first brought in, they had him do an assessment at the David Lawrence Center. At that point, they determined that his risk to reoffend was low. That's talked about in the predisposition report. Your Honor, under 985, juvenile section, 0301 sub 5 sub C, the term of commitment, if you decide to put him into a program, a high-risk program, can be until he's discharged by the program or to the age of 21. You do it till the age of 21 and he stays in that long, you have at least 2 years of counseling. Where if he just goes to Department of Corrections for 8 years, there are not a lot of sex offender counseling programs in the Department of Corrections that he can participate in. When he got out, he would have to find a job, find a place to live, and find work. And if he stays here in Collier County, one of the main places where he would receive that counseling would be Mr. Randall. When we reached out to him, at this point, there's a $350 cost up front for an assessment, and then it's about $160 a month. So without having a job, only being 19 years old, never having any kind of work experience other than working with, as we talked about earlier, his uncle in the cheapy huts. As the state said, there's a punitive measure, and then there needs to be a rehabilitative measure. While they're stressing the punitive, I would argue that the 663 days that he's been in custody is the punitive measure. And now it's time for him to be rehabilitated. If he gets out in society, that's going to be difficult.
So as of today's date, he's been in custody for 366 days?
No, Your Honor, 665 days.
663
days.
663 as of today?
Yes, Your Honor. What we would be asking is for you to commit him to a maximum risk program, to have him go to that program to get the counseling that he needs.
So that would be within the juvenile system?
It would be within you. Yes, Your Honor. The argument for doing that is, it seems from reading the PSI and the PDR that everybody's given up hope on Mr. Arevalo. They did it when they direct filed. His juvenile probation officer said, look, we've lost jurisdiction on misdemeanor batteries. Even when the probation officer did the PSI, she was asking for 10 years prison. He needs to get some sort of counseling, he needs to get some help. And if we just put him and send him to prison and do probation afterwards, he's not going to get that help. He is a very low risk to reoffend. We would ask to have him sent to the juvenile sanctions.
Now, if the court is reluctant to do juvenile sanctions, is there an alternative argument under the adult criminal punishment code?
We would ask for youthful offender after that. That 565 kind of goes through all of the dispositions that the court can do. As you're aware, there are the adult sanctions for, going to take them and send them to prison. There are also the youthful offender and the juvenile sanctions. It even gives you a list of things that you can look at, Your Honor. The sophistication and maturity of the offender. You've seen the way that Mr. Arriangments acts in court. You've also had the opportunity to hear from Dr. Forrest about his maturity level. I think when you look at it as a whole, Your Honor, we would ask you to find the juvenile sanctions.
Any rebuttal?
First of all, Judge, Ms. Onion is now 19 years old. So if you were given juvenile sanctions and placed in even a maximum risk program, as Mr. Barger indicated, the program would lose jurisdiction when the defendant turns 21. So you'll be in this program and released at 21 with no follow-up probation to monitor how in fact he is behaving or any recidivism that may not take place. Further, Judge, it should be noted that the Department of Juvenile Justice does not recommend that the defendant be given juvenile sanctions. In fact, the report from the Department of Juvenile Justice said that he should be punished as an adult. The sex offender probation entails an extensive period of treatment. I know that Mr. Barger indicated cost would be an issue for the defendant, but there are sex offender treatment programs that the cost is based on a sliding scale, depending on where the defendant falls on that scale, will depend on how much he needs to pay. There's the juvenile sanctions don't afford the court the ability to monitor and ensure that the victim and that the community at large will continue to be safe from this individual. Further, we would be placing him in a program with other juveniles, which, given the nature and the facts of this particular case, may not be the best situation because this was, in fact, a crime on another juvenile. And as far as the youthful offender statute, although permissible under the statute, the state would submit that it's not appropriate given the facts and circumstances and the nature of this crime and the egregiousness of this crime, of this individual, a trusted individual who preyed on his 8-year-old sister. And so we're asking that he be sentenced as an adult.
So the state does not contest that he would meet the eligibility requirements for a youthful offender, but on the second level, you're arguing that it should not be ordered.
That's correct.
Mr. Maresca made some allusion to this, and I just wanted to clarify if you're in a position to do so. He seemed to say that one of Mr. Arriangments' juvenile cases that was lowered involved a drive-by shooting, I think is what was the reference. Is there, can that be clarified?
That's correct, Your Honor. It did in fact involve a drive-by shooting, and the defendant was given the benefit, because he had no criminal history, of fleeing to a battery in that particular case. So he's already received leniency from the court, and yet here we are again with an equally, if not more heinous crime. That charge did in fact involve a firearm.
What is the case number for that case?
I can just one moment, Your Honor.
Yes.
I'm happy to provide that.
While she's doing that, Mr. Barger, do you wish to respond at all as far as the facts of that case? Is there anything you wanted to point out about the facts of that case that was being mentioned?
And Judge, it is 18 PJ 284.
Anything else from the state?
No, Your Honor.
Mr. Barger, anything else?
Just that it wasn't a beauty pen, Your Honor. It was not an actual farm.
I believe that concludes the sentencing hearing. It's obviously a sensitive matter involving individual victim that of young age, and then Mr. Arevalo, who himself is just recently turned to be an adult. I have had extensive evidence presented previously, including expert testimony, reports, and today's arguments. I do want to give this some consideration. So I'm prepared to set a date for the sentencing decision that can be in the next 2 weeks for the court to make its decision.
Judge, I'm not sure if Mr. Mark can for the score sheet or if Your Honor would like a copy of
I do have a score sheet. Has there been any changes to it, Mr. Barger? All right. So I do have that. Let me go ahead with my assistant and your schedules and set this for the court's decision.
Judge Manalich's office.
Hello, Melissa. On the Arevalo case, I need to set that for a sentencing determination. The evidence and arguments are complete. I would be looking to set it approximately 2 weeks from now.
Okay, is the defendant in custody or out of custody?
He is in custody, would need to be present. Mr. Barger, does the defense wish for him to be in person, or does it matter if he's by audio visual, depending on room assignments?
It doesn't.
Does the state have any comment on
the
that?
state would defer to the court.
So you're okay if it can be either way, as long as he's present, either by audio visual or in the courtroom?
Yes.
So it can be either, whatever is easier to arrange, Melissa?
How about June 16th at 3 o'clock?
Let's have the attorneys check their schedules.
Judge, I will make myself available anytime, however, Wednesday afternoons I have no help for it.
No, that's fine. Obviously, we'll look for another
Other
day.
than that, I will make myself.
No, that's fine. Let's look for another day, Melissa.
Okay.
I don't want to go too much farther out.
How about June 17th at 1:30?
We'll see Ms. Cunningham's pledge if it holds. You're gonna be okay for that, Mr. Cunningham?
Yes.
Mr. Barger?
Yeah, look at Your Honor. I think we've got something else at 2 o'clock.
So you're okay,
Yes,
June
I'll-
17, 1:30, Melissa?
Yes.
All right, it is set. Thank you for your patience, Mr. Revel. No, thank you. All right, I see both Ms. Mead and Mr. Khalil are here. Any request as to what is next?
We have a quick one, Mr. Carlosa, he's in the back. I believe that's just a
Right, I do need, however, to provide some reasoning for that. And I didn't know, Mr. Khalil, if Mr. Carvalhosa's spouse was going to be here for that.
She did indicate she would be here, however, I haven't spoken to her or seen her.
Do you know what time she I thought we set this for 2:30. So I'm not inclined to call it right now because I think it was set for 2:30. She did indicate she wished to be here.
Okay.
So Ms. Mead, is something we can address for you?
Yes, Your Honor, I have a clue.
All right, which case?
Amber Payne.
All right, Ms. Payne, if you can come up, please.
Judge, pancakes, please.
Yes.
Case number 2020 CF 630, Your Honor.
All right, Ms. Payne is present. Hello, Ms. Payne.
Hello.
Have a seat.
Your Honor, she's going to withdraw her previously entered plea of not guilty and to 1-1 contest.
He will receive a withhold of adjudication on the possession of a controlled substance. Be sentenced to 12 months of probation, substance abuse evaluation, follow recommendations. She will be subject to random drug testing. She will pay court costs, cost of prosecution in the amount of $100, and cost of investigation to the Cuyahoga County Sheriff's Office for $298.
State clarification?
That is correct.
Ms. Payne, do you understand and accept these terms?
Yes.
Any questions?
No.
Please raise your right hand, be sworn by the clerk.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Thank you. May I lower your hand, have a seat, and please answer the state's questions.
Good afternoon. Please state your full name for the record.
Amber Payne,
Your full name.
Amber Nicole Payne,
And what is your date of birth?
3/17/85,
And the last four digits of your social security number?
1820.
Have you ever been known by any other name or alias?
Yes, Amber Presley,
And how do you spell that last name?
PRESLEY.
Any relation to Elvis?
Yeah, I mean,
Okay. And have you ever been arrested under that name?
no, it's okay.
And where were you born?
Elwood, Indiana,
How far did you go to school?
8th grade.
Can you read and write and understand the English language?
Yes.
And are you under the influence of any drugs or alcohol?
No, ma'am.
Are you taking any medication?
No,
Are you suffering from a mental condition or disorder?
no,
Do you understand why we're here today?
yes,
In 20 CF 630, you are charged with count one of the information with possession of controlled substance as a third degree felony punishable by up to 5 years for prison. To that charge, I wish you please.
I know that.
And do you understand that if you violate the conditions of your probation and the court actually adjudicated you, you would lose your driving privileges for
Yes,
6 months, and that's required by statute? And you understand that if you were violating your probation and you were able to prove that it was work substantial, then you could receive up to 5 years.
Yes.
And you can make that. You understand? Do you understand that when you're in plea, you're waiving your right to have a jury trial?
yes,
And you're waiving the right to have that jury determine whether you're guilty or innocent. The right to have the, the right to see and hear the state's witnesses testify and have your jury question of witnesses. The right to call and subpoena your own witnesses, get evidence from another past. The right to choose to testify at that trial or choose to remain silent, and the silence could not be used against you. You're also given up the right to have the state prove this charge beyond without giving all those rights have been included.
I understand.
Counsel, have you observed the advantage of field?
No, no,
Now, do you understand you're given up the right to fill on all grounds except under the court and sentence you here today? I'm going to show you a 3-page worksheet. You have a chance to go over the document with your attorney,
yes, ma'am.
and it shows that you scored 17.6 points.
Yes.
And for a maximum of 5 years in Florida State Prison. Is that correct?
Yes.
And I'm also showing you a 2-page complete one about that. Did you have a chance to go over this?
Yes.
And did you understand everything on it?
Yes, yes,
Did you discuss it with your attorney?
yes, yes.
Do you have any questions you need to ask her with regards to this?
No,
complete one? Right. Right on the back, is that your signature?
yes, ma'am.
Did you sign there to indicate that
Yes,
you
ma'am.
understand all the rights that's on this complete one? And that you're agreeing with all terms and conditions? And did you sign that here?
Yes.
And did you sign that to indicate that you're satisfied with your attorney? I think much contained in the state form and everything takes up from there. Do you want promise to the
No.
Are you entering this plea of your own free will? Are you being forced, threatened by anyone? And are you completely considering your options to believe this plea is in your own best interest?
Yes, ma'am.
And you understand that you're being placed on probation and there's no guarantee that you'd be allowed to terminate or you'd be able to apply, but there's no guarantee that you will terminate.
But I might be able to.
Right.
Yes.
Are you satisfied with your advice, counsel, and attorney? You've done everything you've asked and answered all your questions? Are you aware of the specific defense that you have in this case that you're getting, that you should have come forward on?
I'm sorry.
Was there any motions that might have been filed in this case that you chose to waive instead of leave in the case?
Everything was fine.
Ms. Mead, were there any potential motions, including search and seizure?
Suppress, Your Honor, and Ms. Wilson and I discussed it, and actually this plea offer was based on that motion, so we withdrew it, and
Ms. Payne understands that she's
I
giving
didn't
it,
understand what she said, yes, I did.
she understands she's given up her right to have that motion heard and possibly appealed.
Yes, we discussed that.
All right.
And, Counsel, have you reviewed all the discovery in this case at the time?
Yes, I know.
And then you agree with that? Is there anything you wanted to bring up? I'm unaware of these physical evidence that could be tested for DNA. So you would agree with that?
Yes, I would agree with that.
Ma'am, do you understand if you're not a U.S. citizen, you may be subject to removal or deportation as a result of this plea?
Yes.
And do you understand if you are deported as a result of this case, it will not be a basis to withdraw this plea?
Yes.
Do you need any additional time to discuss that with your counsel?
No.
Did the offense to which you're pleading is sexually violent offense or sexually motivated offense, or if you have previously been convicted of such an offense, this plea may subject you to voluntary civil commitment as a sexually violent predator contemplation under civil. Do you understand this one?
Yes, I do.
Must you stipulate the factual basis of the news?
I do.
Around this time, that they would ask the court to judicial notice, 520 CF 630.
Ms. Mead, any additional defense requests?
No.
There are no competency issues, Ms. Mead, affecting entry of the plea?
No. The only thing that we would ask is that she may be transferring her probation here in Florida.
Okay, do we know to where?
No, we're looking for a house, but we don't know. It's my first home in buying. I'm not quite sure what county.
Court will note on the judgment and sentence, the court authorizes transfer of supervision out of county. And Ms. Payne, do you believe this agreement is in your best interest as opposed to litigating the charge?
Yes.
Okay. And you've had enough time to speak with Ms. Mead about the decision?
Yes.
Is the gentleman in the back also with you? All right, and have you had time to speak with him about this, if it matters? Okay, very good. At this time, based on the plea agreement, the plea colloquy, the plea of no contest, and the arrest affidavit facts in support thereof, court accepts the plea agreement, withhold adjudication as agreed, as further agreed 12 months regular supervision, may transfer out of county, reporting today, Ms. Mead,
Yes.
here in Collier. Substance abuse evaluation, follow any recommendations, any time frame on enrollment in the evaluation? Was any discussed?
We can discuss it. Normally it's 30 days, but we will not discuss it.
Enroll,
That's fine, Your Honor.
so to enroll within 30, all right. Is there any objection or request for hearing, Ms. Mead, on any of the monetary amounts?
No, Your Honor.
What are the court costs, Madam Clerk?
415.
Okay. Random testing is also agreed to. And all monetary amounts as previously announced are approved. Anything else to be addressed?
No, Your Honor.
Okay, was that Elwood or Elmwood?
Elwood.
Elwood, is that near
The heart
Kokomo?
of it, it's the heart of, yeah.
Okay, is that near Kokomo?
Yeah, it's right next door, like we're right in the middle of Kokomo.
Officer Harrison is from Kokomo.
Marion and Muncie.
Okay, Officer Harrison's from Kokomo, is that right?
I know a lot of Harrisons, actually. A lot of them.
From Kokomo?
From Kokomo, from,
Which Harrison's from Kokomo do you know?
I know the younger, my age.
Well, I'm not too much younger than you.
All right, thank you for resolving your cases, thank you. All right. Trivia always gets the best of us,
Yeah.
all right.
Hey, it's home of rolled gold ketchup.
You did say that.
The best. Little fun fact.
All right. Mr. Khalil, who else is in the audience?
We have Miss Nicole Garvinsky.
All right, Ms. Garvinsky, you'll be next. And Mr. Khalil, do you represent the lady in the front row?
She's here for Mr. Humphrey.
All right.
Yeah.
All right, hello, Ms. Garvinsky.
No, this will be a plea of no contest. The resolution is a withhold, 18 months of probation, substance abuse evaluation, well, recommendation for any testing, court cost prosecution, and cost investigation.
Any investigative costs?
Your Honor, I did not receive the copy yet.
What are the court costs?
$415.
Okay. Any public defender charges?
Yes, Your Honor, public defender fees.
150 total?
Yes.
All right.
And your count 2 is a misdemeanor. Count 1 and 3 would be 18 months. Count 2 would be withhold education, 12 months probation. And for all counts, the substance abuse evaluation would be to get signed within 30 days.
And it would all be state probation
Yes.
and concurrent?
Yes, Your Honor.
All right. Ms. Garbinsky, any questions about the plea agreement?
No.
Do you believe this is in your best interest?
Yes.
Please raise your right hand and be sworn by the court.
Do you swear or affirm that the testimony that you give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. May the lower your hand. Please answer the state's questions.
Ma'am, would you please state your full name and record?
Nicole Gabrielle Garbinsky,
And what is your date of birth?
December 12th, 2000,
And the last four digits of your social security number?
7437.
And, have you ever been known by any other name or, alias? No. Where were you born?
In Naples,
How far did you go to school?
10th grade.
Can you read, write, and understand English language?
Yes.
Are you under the influence of any drugs or alcohol?
No.
Are you taking any medication?
No.
Are you suffering from mental condition or disorder?
No.
Do you understand why we're here today?
Yes.
You are charged in count 1 of the information in 20 CF 1674 with possession of controlled substance. It is burglary, felony, punishable by up to 5 years in Florida State Prison. To that charge, do you wish to plea?
No contest.
In count 2, you're charged with possession of paraphernalia. It's a first degree misdemeanor punishable by an additional 1 year in the county jail. To that charge, do you wish to plea?
No contest.
You're charged with possession of controlled substance. It's also a third degree felony punishable by an additional 5 years in Florida State Prison. To that charge, do you wish to plea?
No contest.
And you understand that counts 1 and 3 are drug charge. And that means that if you violate your probation, not only could you become a convicted felon, but you receive up to 11 years in either jail or prison. In addition to that, your driving privileges will be suspended for 6 months. Do you understand that?
Yes.
Do you understand that by entering this plea, you're waiving your right to have a jury trial?
Yes.
You're also given the right to have that jury determine your guilt. The right to see and hear the state witness testify, the attorney's questions. The right to call and subpoena your own witnesses and submit evidence on your own behalf. The right to testify at that trial or choose to remain silent and silence would not be used against you. And lastly, the right to make the state prove the charges beyond reach without dealing with all of those rights by attorney's state. You understand that?
Yes.
And Councilor, have you heard any matters for appeal?
I have not.
And do you understand that, like, clearly you say you're giving up the right to appeal on all grounds except for whether this court can sentence you?
Yes.
And I'm going to show you your 3-page score sheet. It shows that you have no prior criminal history. You scored 18.6 points and to a maximum of 10 years in Florida State Prison, in addition to 1 year in the county jail. Is the score sheet accurate?
Yes.
And I'm also going to show you the 2-page plea form that's right back. Did you have a chance to read over this plea form?
Yes.
And did you understand everything on it? And did you discuss it with your attorney?
Yes.
Is there any further questions regarding the plea form?
I don't.
All right, and is this your signature right on the back?
Yes.
Did you sign that to indicate that you have read all the rights that's on this form, understand everything, and that you're reading all the terms and conditions of this plea?
Yes.
Did you sign right there to indicate that you're satisfied with your attorney?
Yes.
Other than what is contained on the plea form, what was discussed in the rest of the plea, you anything in this plea?
No.
Are you entering this plea in your own free will?
Yes.
Are you enforced or threatened by you?
No.
Are you pleading because given your option to leave this case in the government? Now, do you you understand that there's no guarantee that you'll be able to terminate from probation early in the case? Yes. Are you satisfied with the advice of counsel attorney? Yes. Did I have everything back and answer all your questions? Yes. And counsel, have you reviewed all the discovery in the case of your client?
Yes.
And you agree with that, you monitor that? Yes. All right. And was there anything you wanted to review in this case you didn't get a chance to review? No. I'm unaware of the physical evidence that you tested for DNA. You agree with that?
Yes.
Then you understand that as a result of this plea, there's not going to be any DNA testing done? Yes. You understand if you're not a U.S. citizen, you need subject to removal or deportation as a result of this plea? Yes. And you understand if you are deported as a result of this case, will not be a basis to withdraw the plea? Yes. And do you need any additional time to discuss that with your counsel? No. Difference with your plea in sexually violent offense or sexually motivated offense, or if you have previously been convicted of such an offense, this plea may subject you to involuntary self-commitment as sexually violent predator upon completion of your sentence. Do you understand this morning? Yes. And I'm just going to back up to make sure you understand. You understand that if you violate your probation, and the court finds that you willfully and substantially violated your probation, you could get up to that 11 years that we discussed, if you're in prison, yeah, and that this also could become convicted. Yeah. Did you understand? Yes. Your Honor, at this time, the state would ask the court, I'm sorry, you need to stipulate the fact that you need to.
I stipulate.
At this time, state would ask the court to take condition of 20 CF 1674 and state to.
Any other defense request?
No, Your Honor.
Based on the plea agreement, plea colloquy, the pleas of no contest, and the arrest affidavit, the facts, the court accepts the plea agreement, imposes the terms as agreed, counts 1 and 3, withholds of adjudication, concurrent 18 months state probation, reporting today. Count 2, the misdemeanor, withhold, and 12 months concurrent supervision, all as part of state probation. Substance abuse evaluation, follow recommendations, enroll within 30 days. Very well. Random testing as agreed, court cost $415, prosecution $100, no investigative cost, public defender total charges $150. Any request for hearing or dispute on the monetary amounts?
No, Your Honor.
Anything else from either side? Thank you for resolving your case. Please step over here for the prints. We will take a 15-minute recess. I'm told that the Pages case that was scheduled for 45 minutes may be resolved by agreement. If the parties are ready, that should be very brief. I'll start with that and then address Mr. Caraballosa.
Thank you, Your Honor.
All right, 15-minute recess. Thank you.
All right, you too, Your Honor.
Thank you.
And apparently there's been
about this guy that went into the canal here. Don't want that guy, right? This is bad.
Mr. Smith, are you connected?
I am, Your Honor.
Mr. Smith, Ms. Wilson for the state on 17 CF 1339, State v. Pages. This was set for a 45-minute restitution hearing. However, I'm informed that the parties may have resolved the issue.
I believe we have, Your Honor. my client had mentioned something that she wanted to remain in Collier County for an extra month the last time we were there. And I spoke with the state attorney, and what we thought we would do is set.
Is now present. Hello, Ms. Page.
The arrangement that we had come to was that she was not going to contest the restitution amount as long as she stayed in Collier County for a little bit over a month, and that's kind of where we're at, Your Honor.
So what is there an issue as to the restitution or not?
There is not, Your Honor.
Okay. And Ms. Page is shaking her head. I think, no, there's not an issue. And she's been sentenced previously.
That's correct, Your Honor.
Yes, Your Honor. Penny was on here for Mr. Frazier. Your Honor, I have a civil lien restitution order in the amount of $10,000 to 7 Food Mart and Tortilla. I'm sorry, I got it wrong. It is 1680 40th Terrace Southwest, Naples, Florida.
So, Mr. Smith, have you reviewed this order?
I have, Your Honor.
Okay, so this is a civil restitution lien order that defendant Crystal Pages shall pay to the victim 7 Food Mart and Tortilleria, right, which means the tortilla place, in Naples, a sum of $10,000. And Ms. Wilson, the state is proffering that these are provable losses that they suffered from the robbery.
That is my understanding from Mr. Frazier. Your Honor, he's the one actually prepared the order and then emailed it to me.
Ms. Pages was convicted under principal theory with the 2 co-defendants. So it was joint and several liability, is that correct, including for the restitution?
That's correct, Your Honor.
So she may or may not owe the whole amount, depending on what happens with the co-defendants.
That's correct, Your Honor.
Ms. Pages, do you have any questions about this?
No, but I am still receiving a subpoena for court. I was wondering why I received that, since I'm no longer testifying.
Okay. Does Ms. Wilson is a state, I assume that's a state subpoena, is that correct?
Yes.
Yeah. Ms. Wilson, do you know what the status is on that?
I do not.
Mr. Smith, do you have any information on that?
No, Your Honor. My client's plea agreement was one where she was not going to cooperate, so I don't know why they'd be subpoenaing her.
Was it specifically agreed that she would not be called as a witness, or simply that she would not be cooperating?
She would not be cooperating. It was a non-cooperation agreement. The agreement that she had prior to that was a cooperation agreement. So I'm assuming that she's not going to be testifying.
Well, in any event, if you could follow up for her on that in communication. Ms. Wilson is not the regularly assigned assistant state attorney. It's Mr. Frazier, I believe.
Yes, Your Honor.
So if you could clarify that for Ms. Pages, I think she is entitled to know whether she's still subject to being called in the case or not.
I understand, Your Honor.
Your Honor, if she's considered a witness in the case, then after she's most likely to act her as a witness, and now she's under subpoena before until that case is resolved. So he should check into that.
Right. So if there's an issue, it can be addressed by motion. If there is an issue, hopefully there is not. But you will follow up on that from Ms. Pages, Mr. Smith?
I will, Your Honor. I'll contact Mr. Frazier.
Now, at this point, there's no reason for, obviously, Ms. Page is entitled to get credit for all time served. Have we calculated that through today by any chance? Because this was a Department of Corrections sentence.
I don't think we had. I know we had calculated it at the time of sentencing.
Well, I assume that at this point, there would be no reason that Ms. Pages would continue to remain in Collier County?
Not unless you wanted to, Your Honor.
Right. And we do need for the judgment and sentence to list credit for all time served, which he is entitled to. Mr. Smith, would you be able to get that from the jail so we can include it on the judgment and sentence?
I can do that, Your Honor.
Thank you. Any other details, Madam Clerk? I believe we did the plea colloquy, the court imposed sentence, everything was done except for this restitution issue. Is that correct? Anything else?
Okay, we have the credit time service.
Through today?
Oh, not through today.
That's what we're gonna need through today. And plus any time, well, if she'll get any, will DOC award her any other additional time beyond today, because there's usually a slight delay in her being transported?
I think they calculate normally the credit time served on the day that she was sentenced. So this is sentencing, I think they do it from that date that she is serving it.
Right. Well, I just want to make sure she gets credit through today and beyond for whatever time she's here. So, Mr. Smith, has it been your experience that DOC will award credit beyond the day of sentencing, or that they would award beyond today's date?
Boy, Your Honor, that's a very good question. I don't know for sure.
I would think in abundance of caution, we would want to have it calculated through today, since this was the last proceeding.
Yes, Your Honor.
And then obviously DOC would do anything from.
Your Honor, I'm told it is 1,433 days.
Okay. And what's your source, Mr. Smith?
My office manager and his calculator. I will go ahead and get an official notice from the Collier County Jail.
Okay, well, he's probably right, but we just want to make sure we've got it.
Oh, he said it was April 8th, yes.
I have the worksheet right here.
Does that sound about right, Ms. Pages? We'll want to get it exact, but Mr. Smith will follow up on that and the subpoena issue then. All right, anything else, Ms. Wilson? I will sign the order for the restitution. Thank you for your cooperation, Ms. Pages. That order is now entered and filed. All right, Mr. Khalil, do you know if the lady that was waiting patiently here
Thank you, Your Honor.
wanted to address, goodbye, Mr. Smith. Did she want to be here for Caraballosa?
No, Your Honor, she had to leave.
Oh, okay, because I don't know if she misunderstood, because I set the hearing was set for 45 minutes, but I was also saying it was resolved. So even though it was set for 45, we're not able to address Mr. Caraballosa.
Yeah, I believe she had to pick up children.
Okay, all right. Well, I was not aware of that. The other thing, I was waiting until 2:30 because of the other individual, which I don't see here either.
No, Your Honor. She may have got the date time mixed up, but I can inform her.
All right, very well. Let's have Mr. Caraballosa join us, please. Mr. Khalil for the defense, Ms. Wilson for the state. There are two cases. 20 CF 951 and 1674. Awaiting Mr. Caraballosa. All right, Mr. Caraballosa is present. Hello, Mr. Caraballosa. And we are here for the court's determination of sentence after having taken the matter under advisement and heard evidence and arguments at the last hearing. There was a lady, do you know what her name was, Mr. Khalil?
No, Your Honor.
Okay. There was a lady had waited here for your case, Mr. Caraballosa. Apparently she had to leave. There was the other lady that testified at the last hearing. I waited until 2:30 to see if she would arrive, and she is not here. This matter is before the court. Mr. Caraballosa entered a plea to the bench, and a full plea colloquy was done. An inquiry was also made, and Mr. Caraballosa indicated he understood the difference between the plea agreement, plea to the bench, and jury trial choices. There was previously plea offers, at least in part exchanged, at least for the first charge, and then there were discussions, but nothing fruitful after that. There are two cases before the court. They have the same charge in, looks like 21 CF 89. So I may have misstated that previous case number. The charge is driving license suspended habitual revocation. In the second case, for which both cases Mr. Caraballosa entered a plea to the bench with pleas of no contest, the charge there in 20 CF 951 is the same, driving license suspended or revoked, habitual revocation. There are some things that are not disputed at this time, which the court will direct. It is an adjudication on each case that is not disputed. There are court costs of $415 in each case that will be ordered, prosecution costs of $100 in each case. There are no investigative costs in each case. There's public defender charges of $150 only, or times two?
It would be 100 on each case, and then one application fee, so 250 in total.
As clarified, that is approved. To the extent it may or may not be applicable, have you calculated credit for any time served at this point?
I haven't hired.
All right, so that would be all credit, I assume, if as applicable. All right. Was a PSI waived in this case?
We'll waive it, Your Honor.
Okay. There was a score sheet presented to the court. That score sheet, which I assume was reviewed and not objected to by the defense?
Yes, Your Honor.
Interestingly, the score sheet, well, no, it does account for both offenses, because the primary offense as well as the additional driving after suspension are both accounted for. That's a total of 4.7 points. The main contributing factor to Mr. Caraballosa's score sheet is his prior record. That adds 29.3 points. The entries on that record include a chop shop conviction, possession of controlled substance several times, possession of a place for trafficking or manufacturing of substances, driving while license suspended or revoked. Appears to be 10 prior convictions. Actually more, it's 17 listed here. 7, 7, and 3. There's also entries for giving false name and resisting without violence, as well as some other misdemeanor charges. So total of 34 points. No minimum indicated, although 34 points is solidly within the county jail range and could, depending on the court's decision, make Mr. Caraballosa eligible for prison, which is what the state is requesting in this case. To briefly review the evidence presented at the hearing, Mr. Caraballosa testified. He is a Golden Gate resident. He is married, has 2 children, ages 17 and 15. He is providing their care. He testified that the reason he was driving on these occasions was that he is a mobile mechanic. He was returning one vehicle to a customer, and he was on the way to another customer when stopped. He understands, he said, that it is illegal for him to drive, but he depended on it for his occupation. He stated that for the future, he wishes to break this pattern of violations. He has set up a payment plan, plans to try to get a hardship license. Testified he did a driver improvement course in 2012, had also enrolled in Dade County's driving legal program but couldn't quite finish it. He has lined up people to provide him rides in the future. His license suspension, he says, was for non-payment of fines. He recognized that he has, in his terms, a bad driving history. He requests a, quote, fair sentence and to go home today. He promised to try to get his license back. On cross-examination, Mr. Caraballosa admitted that he's had 16 driver license suspensions. He's been on habitual traffic offender status since 2005. He has not had his driver license reinstated since 2005. He previously served a sentence of 365 days county jail in June of 2020, which was a month before the first of these 2 cases, involving the same offense. Mr. Caraballosa thought that he had been stopped on multiple occasions by the same officer. Leslie Warner testified. She is Mr. Caraballosa's spouse. She testified and confirmed he is the sole provider for the family. She further testified that she is currently pregnant, has a high-risk pregnancy, is a paralegal student, relies on Mr. Caballosa for support. Ms. Warner stated that she thought it was unfortunate that the state had denied Mr. Caballosa entry into drug court. She mentioned that he was aware that he was a trustee in the jail. She requested the court to place him on supervision. She did admit she realizes that there are collateral consequences suffered by family members from criminal activity. She said that she is confident Mr. Caballosa will do his best and will not be allowed to drive, and she will drive him. On cross-examination, she testified that she recognized Mr. Caballosa had a previous one-year county jail sentence for the same offenses, and she was able to care for the family, but that was before she had the high-risk pregnancy. She stated that the paid drivers that Mr. Caballosa had lined up had essentially abandoned him on these occasions where he was arrested. She assured the court that she would be available to transport him and that he could call her. She recognized he made some poor choices, but she assured the court that she will drive Mr. Caballosa. That is the background and the evidence, the arguments of counsel. The state is requesting 24 months Department of Corrections, credit all time served, concurrent on each case. The state specifically stated that they are not requesting supervision. The reasons, among others, are the HTO status, the number of prior suspensions and driving after suspensions, that there was a previous jail term of 1 year on a violation of probation. The state pointed out that there were 2 different arresting officers on these cases, and that essentially Mr. Caballosa has been driving on a suspended license for 15 years, and that county jail has not deterred that, and that a greater sanction is needed. Mr. Khalil's argued for Mr. Caballosa that he has tried to get his driver's license back and is in the process and has a specific plan. The request is from the defense for time served, or in the alternative, 18 months Department of Corrections suspended on completion of 18 months supervision in getting the driver license. The state said that has not occurred for 16 years. That sums up the situation. Truly, as recognized by Ms. Warner, the collateral consequences of criminal activity are certainly impactful to the family, and the court understands that. It is one of the types of criminal activity in this state that potentially can cause the most harm can be driving related offenses. And Mr. Caballosa not only has many suspensions, but he also has leaving the scene of accident. And in this scenario, he should not be on the road. The question is what to do about it. The court thinks that there have been plenty of opportunities afforded. They have been squandered. There's been a recent 1 year jail sentence that has not deterred. And at this point, regrettably, I believe the state is correct in their recommendation. We have reached the point that this is a punishment scenario, and Mr. Caballosa, to his credit, should try to get licensed legally, but that will be up to him. At this point, he must be removed from the road, and he must be punished for driving a habitual traffic offender. That's as bad as it gets, and that's just straightforward with the scenario we have. So at this point, the state's recommendation of 24 months Department of Corrections, credit all time served, is approved along with the other terms as announced. Any clarifications requested? All right, thank you. That concludes the sentence. Ms. Wilson, would you please print up a clean score sheet, please? I did mark mine.
And Your Honor, I have calculated his credit. Would you like me to give an official one from the jail?
No, if you have it, we can use that.
And Your Honor,
I do want him to get credit through today.
yes, in 21 CF 89, the calculation is from January 14 to January 14, 2021 to the present day is 139 days credit. And on 20 CF 951, his credit would be from July 9th, 2020 to August 1st, 2020, 24 days, in addition to January 14th, 2021 to the present, 139 days, with a total of 163 days for the case 20 CF 95.
Any dispute from the state? That is all approved, Madam Clerk. Do you need him to write those down for you?
No, Judge.
All right, that is all granted. And the terms, the sentences were concurrent on each case. All right, thank you.
Thank you, Your Honor.
I believe the next cases are called at 3:30, the Burgess and Rivero cases.
Yes, Your Honor.
So we'll take a short recess. Let me know if they arrive early and we'll address it early.
All right. All rise. Court is in recess.
Greetings, Zoomers. And we have both the Fort Myers group represented this afternoon. We've got Mr. Harris and Ms. Augustin. And I believe of the two matters, the briefer, well, let me ask which may be the briefer. Ms. Wilson, will the state be opposing Mr. Harris's motion?
Yes.
All right. So we'll have to have some argument on that. Let's begin at the Rivero case, unless, Mr. Harris, you have a conflict.
No, sir.
Very well. Ms. Augustin for the defense, if we can have Mr. Rivero, please. Case number 18 CF 1898. Awaiting Mr. Rivero, who will be in court. Ms. Augustin remotely. Ms. Wilson for the state in court. Ms. Augustin, can you hear us adequately?
I can, yes, Your Honor, thank you.
Very well. awaiting Mr. Rivero. You are covering for Mr. Ashby today, Ms. Wilson?
Yes.
Or are you taking over the case? All right. Mr. Rivero is now present. Welcome back, Mr. Rivero. And Ms. Augustin is remotely connected, and Ms. Wilson is here for the state. This matter is on a motion of the defense to set bond. I will summarize a somewhat lengthy history of this case. Mr. Rivero has been charged in an information with the charge of aggravated stalking, violation of injunction. The probable cause affidavit is supported by allegations brought by the alleged victim of the injunction, who is related to Mr. Rivero, and also allegedly supported by officers that in the probable cause affidavit stated they heard comments by Mr. Rivero when he was calling to the alleged victim. It did include what is alleged as stalking type behavior and future threats. Mr. Rivero was released on bond. It appears that the bond in his case was set on this main charge at $25,000 at one point. And my understanding is there were a couple of other charges: violation of injunction, misdemeanor, failure to register, convicted felon, misdemeanor. Those were set at $5,000 and $2,500. I'm not sure what happened to those charges. Probably got addressed in county court or pending, whatever. But the main charge here was an original bond of $25,000. My understanding is that Mr. Rivero was able to post bond and was at liberty for a significant period of time in this case without incident. However, the state brought a motion to revoke bond, and let me take a look at that motion. Yes, it was a motion styled, a motion to revoke bond, alleging non-compliance with a bond condition, that of GPS connection. The court had an evidentiary hearing, is my recollection, at which the state presented the person responsible for monitoring the GPS. And my recollection roughly is that that individual testified that there were a series of problems and non-compliance with the GPS. Mr. Rivero, to his credit, did show up voluntarily, understanding that the bond could be revoked on the state's motion, depending on the evidence. At the conclusion of that hearing, the court did revoke the bond as requested by the state, and Mr. Rivero has been in custody since, and I believe it is since approximately March of 2020. There was, when previously represented by a different counsel, Mr. Rivero brought a motion for rehearing. This court heard that motion and denied that motion. That was, I believe, also in 2020. Ms. Augustin has taken over this case and has recently filed the motion. The motion cites two different Florida precedents, including and they're all cited in Ms. Augustin's motion, but including the Ginsburg decision as well as others. In the motion hearing, Ms. Augustin argued that Mr. Rivero has been in custody for in excess of 14 months, that he is capable of residing with his mother in Broward County, he has job offers, that he has previously appeared before the court, and that it was the defense assertion that the problems with the the GPS were primarily with the charger, were not intended to be willful, and that he would take steps to prevent that from happening again. The defense stressed that Mr. Rivera has been out of contact with his children for 14 months, and that was a big concern to them. There is a family law situation. Well, I don't know if it's a family law case, but certainly there is issues in the family, and there has been apparently the defense is offering that CAC, Child Advocacy Center, could act as a third-party coordinator for any child care issues. There were defense exhibit number 1 personal reference letters presented in evidence, complimentary of Mr. Rivera, both from employers, I think it was. On cross-examination, Mr. Rivera admitted he does have a significant criminal history. They do include prior controlled substance charges, driving-related charges, petty theft, DUI, and that the score sheet in this case does indicate a 25-month minimum sentence. That was all of the evidence presented. The rest was primarily arguments of counsel. The defense is arguing that there is no new crime committed, and that based on the case law cited by the defense, that this court has erred in denying bond, and that he is entitled to a bond of some type. And the defense also pointed out that there is a prior history that is non-violent, and this is a third-degree felony. And then Mr. Rivera was out of custody for about a year before the GPS revocation occurred. The state argued that this issue has been asked to be reconsidered and previously denied. The state then referenced the statutory framework having to do with bond revocation. In particular, the section 903.046 on the criteria for bond determination, as well as 907.041 on pretrial detention. And the state would point the court to the legislative intent of 907.041. That is, the intent of the legislature is that the primary consideration be the protection of the community from risk of harm, which the state says there is that risk here for the alleged victim. The state then goes on to subsection 4 of that statute, pretrial detention, and points out that the charge that Mr. Rivera has of aggravated stalking is one of the so-called dangerous crimes for which bond can be denied. Including if the defendant has threatened, intimidated, or injured any victim. Or if there is a threat of harm to the community or members of it. Additionally, one moment. No, I think that pretty much sums it up. So, I do have to compliment Ms. Augustin for the research done here, because my review of the case law cited by the defense, as well as a case out of our own Collier County, which I located from the Court of Appeals, as well as a recent case from the 3rd District. The recent case is the Joseph decision found at 46 Florida Law Weekly D 1103. And that case basically cites to Ginsburg and other existing precedents, which, by the way, go all the way back, as cited by Ms. Augustin, to the decision of the Florida Supreme Court in 2001, the Paul case, 783 Southern 2nd, 1042. And my reading of these cases, including the very recent one from the 3rd, I believe it's the 3rd district, that's the Joseph case that I cited too, basically provide that when a defendant violates bond, if it is a new law violation, the court can revoke bond and deny any additional bond. However, when it is a violation of a bond condition that is not a new law violation, then the court, he's not entitled to the same bond as before, but he is entitled to a bond unless the state files a pretrial detention motion. And that has apparently not occurred in this case. Now, I would also cite to Miller v. State, 980 Southern 2nd, 1092. That was a Collier County case arising out of our court. It's quite the reading if you want to care to look at it. The Court of Appeals was not particularly complimentary of either the court or the prosecution in this case. In a procuring opinion, they made it quite clear. But they also made quite clear that if it is not a new law violation and it is a violation of some other bond condition, that the only way that the court can deny bond is if the state files a pretrial detention motion. Otherwise, the defendant, as I read this decision, is entitled to have some bond of some type set. So, based on those decisions, at this point, what I am inclined to do, I would note that in each of these decisions, by the way, the Court of Appeals granted the state between 48 and 72 hours to determine if or whether or not they would file a motion for pretrial detention, despite the fact it had not been filed before. What I'm inclined to do on this matter is I will be setting a bond for Mr. Rivero with appropriate conditions. However, I will allow, consistent with what the Court of Appeals has done, the state until Friday of this week to determine if it will be filing a pretrial detention motion or not. If the state does not, I will set bond for Mr. Rivero on Friday. If the state does file a motion for pretrial detention, then I will have a hearing on that pretrial detention motion on Friday. So either way, it will be determined on Friday. I can set that hearing now. In the abundance of caution, assuming that the state might choose to file the pretrial detention motion. And by the way, simply because the state files that pretrial detention motion does not mean that bond will be denied. I will have to hear what the state's reasons are and determine whether or not a bond should be denied or granted. But it does give the state that opportunity, consistent with what the Court of Appeals did in these other cases. Let me go ahead and set the hearing time this Friday, and I believe it's 2 o'clock. We have time if we need a hearing. Ms. Augustine, are you available then? And you can appear remotely if necessary.
Okay, Your Honor. Yes, we are available.
Judge Manalich is also.
Hello, Melissa. As I indicated, I do need to set Mr. Rivero's case for a determination to be definitively made on Friday at 2 o'clock. We will set it. Ms. Wilson, any issue with that time? All right. So either way, we'll convene. If the state does not file the motion, the court will set a bond as it deems appropriate with conditions. If the state does file the motion, then both sides need to be prepared to argue that motion, and the court will make a decision from the bench on Friday. I will not take it under any further delay. Any clarifications, Ms. Augustine?
Your Honor, Are we allowed to appear in person on Friday?
Yes. Melissa,
Okay.
there's no reason people can't appear in person, correct?
The attorneys can, but the defendants would be appearing by audiovisual on the stand.
Any objection if Mr. Rivero, because of pandemic restrictions, Ms. Augustine, we have limited, courtroom assignments. In order to not delay,
No objection.
he'll appear, then he'll be able to watch and observe, but it'll be by audiovisual. Is that okay with you, so we don't delay this?
Yes, Your Honor.
All right, Ms. Wilson, any issues?
We have no objection to our client appearing via Polycom, but I'm not certain if the state files a motion for pretrial detention, I may decide to appear in person on Friday in the courtroom.
Your choice on that.
Okay, thank you.
And Mr. Rivera will be the audiovisual. And Ms. Wilson, any other clarifications? So Melissa, that's Friday at 2 o'clock?
Yes.
All right, the court will make a decision. Thank you for your patience. All right.
Thank you.
Goodbye, Ms. Augustine.
May I be excused?
Yeah, see you Friday.
Thank you.
Hello, Mr. Harris.
Hello, Judge.
How are you?
I'm pretty good. How are you?
All right. I managed to be able to finally get that Burgess competency order out, as well as the related examination order. I don't know if you all received that.
We did.
And we are, do you wish to have Mr. Burgess appear or waive his appearance, Mr. Harris?
I'll waive his appearance. That's fine.
Right. He was brought over, Officer Harrison?
I believe so.
He was brought over, but it's up to you, whatever you prefer.
Well, if he's in the back room, yeah, he can come out for this hearing. That'd be fine.
Is he here? All right. So if he's here, you want him brought out?
Yeah, if it's already over there, so that's fine.
Fine. So we'll wait a moment.
Okay.
Case number 19 CF 2159, 19 MM 2281 and there's a third 19 CF 2142.
Yes, sir.
Defense motion for consolidation of cases.
Yes, sir. Robert Harris for Mr. Burgess.
Ms. Wilson for the state. All right, hello, Mr. Burgess, welcome back. Your attorney, Mr. Harris, is on remote connection here. And this is Mr. Harris's motion to consolidate your cases for one trial. And Mr. Burgess is present. I also was mentioning to counsel, I recently entered an order finding Mr. Burgess competent to continue on with the case, and also granting the request that was agreed to for the mental health expert evaluation on the, I believe it's the insanity defense.
Yes, sir.
Okay, so that brings us up to current. The state does oppose the motion to consolidate. Is the state opposing consolidation of all of the cases or just some? All right, so it's a complete opposition, Mr. Harris. Do you wish to lead off?
I do. Judge, it is a rare event that the defense wants to consolidate offenses, as the court is well aware. There's not much abiding case law on the issue, I assume, because if the defense moves for consolidation and it's granted and there's an acquittal, of course, there's no appeal. And if there's a conviction, well, there's nothing for the defense to appeal because the defense has agreed to consolidate. I am moving to consolidate these offenses.
It did.
So I don't believe
it strike me as a first impression, Mr. Harris, that there was a calculated risk involved here.
there is, but I believe it's a one worth taking. The reason I'm moving for consolidation is because Mr. Burgess is charged with 3 separate criminal informations. Not that they're separate in terms of causal relation, because they're not. But the brief facts are that on November 20th at about 5:48 p.m., Mr. Burgess allegedly accosts an employee of Arthrex, where he used to work 6 months earlier. He showed up to work that day, and there was bizarre behavior, to say the least, and he ended up grabbing a woman and pulling her towards a door. He was then kind of frisked away, and within the hour, actually within, it's hard to even, the times are a little off, but this looks like it on the same day at 17:39. So it looks like it's within minutes. Mr. Burgess allegedly runs a woman off the road, gets into her car, and throws a debit card at her, and then tries to grab her breasts. A battalion chief, I guess a firefighter, came by, and he stopped, and Mr. Burgess got into his car, and there was bizarre behavior. And then Mr. Burgess was then arrested, and was kicking at the patrol car and all that. He was uncooperative, and he was placed into a holding cell. He was OC sprayed. A couple days goes by, on November 23rd, so 3 days later, Mr. Burgess has not ever come down from this psychotic episode. And I'll explain how I know that in just a minute. But on November 23rd, he was trying to bang his head on the cell door, threw his body against the cell window, climbing on things. They ordered him not to do that. They came in the cell, and he allegedly spit on the officers and was charged with battery on law enforcement officers. Now, in between, as I was saying, I know he never came off of this psychotic episode, so it's certainly, it goes to our defense that this wasn't drugs. If the court limits us to simply November 20th, the state has a better argument that this was drug related. But the fact that 3 days later he's still going through this, he says it's not drugs, but a mental episode. During the intermission between November 20th and November 23rd, I have a report that Mr. Burgess was in his cell, rolling around in his own fecal matter and eating it. It certainly weighed heavily on the doctor's decision to find that Mr. Burgess was suffering from a psychotic episode and was not guilty by reason of insanity. So you've got a 3-day period where Mr. Burgess is basically, I was going to say a colloquialism, but it's not appropriate for court. He was insane, legally insane, going through a psychotic episode. As I said, one of the reasons why I think the court will be on solid legal ground is because this is the defense's request. There will be no appeal if Mr. Burgess is convicted on this issue because we are fully acquiescing. Mr. Burgess knows exactly what I'm doing here. The case law on severance of cases where the defense moves for severance because cases should not be joined as charged by the state. I think one case that I was looking at was Ellis versus State, 622 Southern 2nd 991, Florida Supreme Court, 1993. For joinder to be appropriate, the separate crimes must be linked in some significant way. This can include the fact that they occurred during a spree, or the fact that one crime is causally related to the other. I think both those could be had. This is for lack of a better word, a crime spree. Now, they're not similar crimes, but the behaviors are similar. But the causal relation is certainly one that the defense believes are significantly related from a psychotic episode. And we want to present, whether the court if the court denies this motion, I'm going to bring in all the facts for these 3 cases anyways, in sort of a Williams rule type of issue for the defense. I'm going to argue, if the court says one trial at a time, I'm still going to bring in, for instance, the misdemeanor battery case to show Mr. Burgess was insane. I'm going to bring in the battery on law enforcement officer to show he was still insane days later, so that the state can't argue that it was drug related because it was days later. And I'm going to bring in everything that happened in between these events. So it will not, judicial economy, the witnesses will all be testifying in all 3 trials or one trial. More significant is, I believe, the expense to the county and the state. The doctors will have to come testify in all 3 cases if they're not joined. That's significant economic expense to the state when I'm suggesting another route, which is have them testify in one case before one jury, winner take all, not guilty by reason of insanity or guilty of all charges.
Mr. Harris, without revealing attorney-client information, Does Mr. Burgess concur with this approach for consolidation of all three cases?
Yes, he does. We talked about it just the other day. He's in full concurrence with what I'm doing.
The other question I would have is under Rule 3.151. Two or more offenses are related offenses if they are triable in the same court and are based on the same act or transaction or on two or more connected acts or transactions. The next paragraph says consolidation of indictments or informations, two or more informations charging what I defined above as related offenses can be consolidated. How is the legal standard met here of based on the same act or transaction or two or more connected acts or transactions?
Well, I'll talk about that first. The two or more connected acts or transactions is these acts are connected. Not only the first two are connected by temporal issues, they're within the hour, but causally related, as Ellis said. The fact that one crime is causally related to the other. A trial court must find that a meaningful relationship exists between the charges of separate crimes before allowing them to be tried together. And that's of course, when the state wants it over defense objection. And the danger, of course, in those kind of cases is the prejudice to the defense is, wait a minute, you're bringing in this separate crime, which kind of eases the burden on the state because it's prejudicial to say that the defendant is guilty of this and guilty of this when they should be tried separately. We're saying the opposite is true. We're saying that Mr. Burgess is not guilty by reason of insanity because the three offenses show over the course of these 3 days that he was legally insane going through a psychotic episode, and we're going to bring them in regardless. So it doesn't save anybody certainly any time, and the witnesses any economics here. Now, the second issue I think that the court sees and I see is two or more offenses are related offenses if they're triable in the same court. And I think that obviously we have a county court case that we're trying to consolidate. And as I said, Judge Brown gave us the go ahead to do so. But if one looks at Rule 150, which is joinder. Now, the consolidation rule says in the 1968 the 1972 amendment, it was changes to conform with Rules 150A. 150 is joinder of offenses. And that says two or more offenses that are triable in the same court may be charged in the same indictment or information and a separate count for each offense when the offenses, whether felonies or misdemeanors or both, are based on the same transaction or on two or more connected acts or transactions. So the county court issue is not really a one at all. The joinder says you can bring in misdemeanors. Obviously, that would be tried separately in county court if they were separate, if they should be joined with the felony. And that's what I'm saying with the 20 mm or the 19 mm case. It's a battery before Judge Brown. It occurred around the same time as the most serious offense here, which happened on the road right after Mr. Burgess left Arthrex, evidently.
What, if any, unfair prejudice would occur if the motion is denied?
The unfair prejudice is, I don't know if there's necessarily unfair prejudice. What, other than Mr. Burgess has to go to 3 separate juries. In other words, the prejudice is that he has to convince 3 separate juries of the same defense, which doesn't seem fair on its face. If Mr. Burgess prevails on, let's say, 19 CF 2142, which is the one in the roadway, the aggravated assault and burglary, why should he have to then go to county court and say, within the hour, I was also insane. I've got to convince another jury of the same issue that happened the same hour, but I have to go to a separate jury. That seems on its face unfair. Now, I would say that the state has a better argument on keeping the separate cases from different days. But again, if it's the same psychotic episode, if it's the same causal relation, I don't see the point of it. I don't see how there's any prejudice to the state if we're bringing in 3 separate crimes where they get to argue Mr. Burgess is a crime spree all on his own. They get to make all those great arguments that we usually argue against for joinder against Mr. Burgess. But the point is,
from a trial management standpoint, if this is granted, how does this not result in confusion of issues for the jury or an unmanageable lengthy trial?
I don't think it does. Well, for one thing, Judge, it doesn't lengthen the trial at all, because if the court denies this motion, like I said, the defense is going to bring in all the witnesses from all 3 events in all 3 trials anyways. It's not going to shorten the trial. Additionally, I don't think the jury's going to be confused when the defense gets up and says, ladies and gentlemen, these offenses are all based on the same defense that Mr. Burgess was going through a psychotic break, started sometime before November 20th and ended sometime after November 23rd. We're going to present evidence for all those days that he was legally insane or going through this mental unfitness episode. I think it's more confusing for the jury for me to bring in, let's say in the 19 CF 2142 case, I bring in a case from 3 days later and I go, hey, this proves he's insane. Why don't we just try them all and say he was legally insane for all these? The defense is the same, the jury instruction is the same, everything goes to a similarity and a causal relation. The state is going to argue they're causally related because he was just on drugs or just a bad person. And we're going to argue, no, the causal relation is one psychotic break that he went through, and the doctor, at least one doctor is going to testify to it. We'll see what the second doctor has to say about it, but I believe that he's either going to say that Mr. Burgess was legally insane for all of it, or he was, legally sane for all of it. I think that we have a situation where this makes a lot of sense, both for keeping it simple for the jury, for keeping the economics of the case down, and for judicial economy of the cases. 3 separate trials with all the witnesses. Let's say it's a 3-day trial. That's 9 days. 9 days of trial time. We're talking about maybe it increases a little bit. I don't know. Maybe we're talking about 1 4-day trial as opposed to 3 3-day trials. That's my point. Is we're going to save a lot of time and a lot of judicial time and a lot of money by doing it in one case. And it also is exactly what the defense wants. So there'll be no appeal. And I think the case law supports it. And like I said, I'm going to Williams rule, for lack of a better word, all the cases into one anyways. Thank you.
All right, Ms. Wilson.
I think, Your Honor, in regards to the Williams rule, that's something you can put a motion for the court to determine whether or not it is appropriate.
Are you able to hear her, Mr. Harris?
No, can she speak into the microphone a little bit better?
If you can try, or we can have you come up to this microphone up here, Ms. Wilson. Try again with a little louder.
In regards to the Williams rule, that is another motion that would have to be brought from time by the court to decide whether it's proper for the Williams rule to come in and have these cases brought into one case in regards to argument for.
Any butter, Mr. Harris?
I'm hearing every other word. I think you said about Williams rule.
Are you able to come up here and see if we can do better?
Your microphone is great.
All right. That's something I will need to consider in the future. This may hopefully help if she's closer.
Okay, I said that in regards to the Williams rule argument, that's going to be another motion that would have to be heard by the court. That can be determined whether the court's going to allow that in a trial. And I would disagree that it wouldn't lengthen our trial, especially if it's limited as we are in the next few months with trial space of 2 weeks. I don't see how we have cases that take 20 seconds. One of them could be 4 days long, but then we have experts on both sides testifying, and then we have 2 or separate fact cases in there. I don't know if we can get it done even in a 2-week period. At this point, we don't know. However, I don't think, Your Honor, that it appears in reading the rules
that it's the intent of the legislature to actually consolidate offenses just to save time in regards to having the defense witness testify for purposes of what their defense is, in this case being insanity. It clearly states that they are to, that there's, let me find the exact wording so that she can, like the court stated in both rules, is that it is to be based on the same act or transaction, or two or more connected acts or transactions. It doesn't talk about some type of offense or anything else. I don't think it's the legislative intent. In addition to that, Your Honor, unfortunately, I printed these out, like sent to the court and all. Mr. Harris, I'm looking at Crosley v. State. It's a 1992 Supreme Court case, and it's 596 Southern 2nd 447. And Your Honor, I may have given you my copy of that. Although it might be helpful, I don't want to highlight something. In this case, Your Honor, this is a case in which there was a defendant. He was charged with armed kidnapping and 2 counts of armed robbery that arose out of 2 separate incidents on the same day. And what happened is there is a Miss White. She's a waitress at a restaurant. She finishes work, comes out the parking lot. The defendant actually orders her by gunpoint to slide over. He gets in the car and kidnaps her. About 4:00 p.m., he pulls over at a liquor store, tells her to get out, and then he leaves with her car and a purse. About 3 hours later on the same day, Miss Jones is a cashier at a store. He goes in there, he pulls a gun on her and holds it next to her stomach, takes the money from the cash register and leaves. The appeals court in that case had found that the offenses here are significantly close temporarily, which is something that was argued here, geographically and factually. The crimes were separated by a period of only 2 hours and 45 minutes, occurred only 2 to 3 miles apart. Both involved armed robbery commencing on the property of a commercial establishment, and both the robber approached female victims, pulled a gun on them, and both victims identified the robber as a black male wearing a cap, dark sunglasses, a blue shirt or jacket, and gray shorts. And based on the temporal, geographic, and factual closeness of the offenses, the trial court did not abuse its discretion in denying the appeals appellant's motion for severance. And as Mr. Harris has stated, all the cases seem to be, it was severed, and whether it's proper or not. However, the language is the same.
Well, isn't this case, though, and others like it, primarily focusing on the prejudicial impact on the defense of joining these acts or transactions that may be separate to a certain extent, and that they may convict because of whereas here, it's the defense that's requesting this based on that it represents one continuing psychotic episode.
I agree with that, Your Honor, but again, it's whether or not to be able to put it together, we have to look at whether it's proper to consolidate the cases. And so what the Supreme Court does is, and they do mention the fact that, there's a practicality and efficiency that, of course, that the court does look at, but it's also in its right to a fair trial. And the danger of improper consolidation lies in exactly what the court talked about, in the fact that the evidence relating to each of the crimes may have the effect of bolstering the proof of the other.
So we're looking at this in a backward type unusual scenario, but is there unfair prejudice to the state from this consolidation?
Well, Your Honor, I would argue the fact that, one, I know that they can't kill a lot of stuff, but I don't see how it couldn't be a 3850 motion, because he's getting his advice from his counsel. His counsel's doing it. He comes out and they find him guilty and not guilty due to reason of insanity.
Even if I just asked whether defense counsel, without revealing attorney-client, defense counsel has confirmed to the court's question that Mr. Burgess is in agreement with this approach.
I think it still comes down to it after the fact, not being found guilty of him arguing, well, I've just taken the advice of my attorney. And he said, this is the way to do it. So, you know, that's a prejudice there, us coming back and draw those witnesses, and then of course trying to put on 3 trials in one, when in reality these are separate acts, and it's only for the convenience of the defense. Which again, he can put his witness on, his expert on, come in and say what he based his expert, you know, findings on. So, you know, I think that's not one thing that I think is lost in this case, the fact that he wants to consolidate them together and have one trial.
Well, doesn't the state and the public also have an interest in reducing costs by having these experts all brought in one time and not in 3 separate trials?
But is it really not prejudicial with what the court state can have multiple different acts that's going on? I mean, there's not just, you know, like 3 separate batteries. We have multiple offenses that are involved in 3 separate batteries, other cases. And so you put all those together, you know, and I think it could be, especially when different time, different facts, different days, you know, I think that's going to be very confusing for the jury, and I think that is prejudicial to the state, that it's not kept cleaner than that. But the one thing I noticed that the Supreme Court says in here, they're just stressing on that, is that the court must be careful that there's a meaningful relationship between the charges of 2 separate crimes before permitting them to be tried together. So that's where I was getting to in here, is the fact that they go down that, talking about this case that I just mentioned here, is in the instant case, both robberies were committed within hours of each other and only a few miles apart. However, the 2 episodes were entirely independent. There were absolutely nothing to connect one crime with the other. Though Crosley was arrested after the Jones robbery while driving Miss White's car, there is no evidence that Crosley used White's car to perpetrate the Jones robbery. The money in Crosley's possession when he was arrested was not identified as having come from either robbery. Thus, we hold the court erred in refusing to sever the trial of the Jones robbery from that of White's robbery and the kidnapping. So then the state went on to make a different argument that the court didn't go on either. But Your Honor, here's one in which it's probably even more related. The fact that he robs this person, takes her car, and goes down the street, and within 3 hours actually commits, and like the same type battery of crime, Your Honor. In this case, we have him go to our threats, commits a battery there. He leaves, he does, before he's caught, he actually goes behind a woman and hits her from behind, gets in there and grabs her, as Mr. Harris has stated. Then he also damages the police car while he's there. And then it's days later that he actually batters a law enforcement officer in a jail. So these are separate acts that have been charged separately because we did not feel that there was enough of a relationship between them. And there's nothing in the rule that indicates that they become the same act or transaction. And I definitely couldn't find a case law that states so, based on the fact of what the defense wants to argue as their defense of the case. So in this case, it is based on the Supreme Court case and how it closed it. And similar, these 2 are in this Crosley case, Your Honor. I don't see how, based on that somehow or another the acts or transactions in these 3 cases have anything to do with each other. And when it comes to the battery that occurred at our threats, that is a misdemeanor charge. And because it is not the same act or transaction, then therefore the jurisdiction is in the county court and not in the circuit court. So that would not apply.
Sure, Harris, hold the thought. I did a long distance run this morning, consumed a ton of fluid. I just need 3 minutes and I'll be right back, all right?
I know how that goes. I know how that goes.
Give me 3 minutes, I'll be right back.
Okay.
I have to restrict these drinking. I know. I could use some.
All right, I'm taking this off the record.
You won't have to get in the small cup.
Let's drink right now. Oh my God. He offers us a Pop-Tart. here's the code.
We're not. Oh, we're not. Are you crazy? We're not getting there now. What? No, it's the there's always hope.
Oh, now the Steve
Huh? Oh, I think you. It's still raining outside.
Did it start raining?
Oh my God, it was pouring out there.
Oh, my goodness. I didn't even see that.
I thought it got cold in here.
You know, these are usually a great mask, not to steam up.
Today?
Maybe it's just too humid. So there's still enough getting through, see? So I tried to make that, but then I put it's not. It's too hot.
You need me to hold on to
Yeah, but it's right there. I think I got everything off the case. But like, I can't see.
Oh, my goodness. Oh, I don't want to start on the case. Oh my God, you could have argued this to a morning. What the hell goes this point?
Are you tired?
I'm ready to go, and this is a motion that's on my plate for seven.
I'm hoping not.
Because it's like going around this purpose, same thing. What? Keeping our figured that out for you there.
Rain now.
Sorry, I have to.
It's all in here.
Stop it.
I can hear it.
Yep. Yep. It's coming in. All rise, Carter County Circuit Court is back in session.
Thank you for your patience. Please be seated. Sorry about that. There's about 80 to 100 ounces of fluid, and that's, anyway, go ahead.
Judge, I'm gonna ask you to remember that when I need the same relief during a trial.
It's a good excuse, but.
Thank you. Look, I think the Crossley case has some good points that I should make, and that is that, as the court so wisely pointed out, it was the defense objecting to this motion for consolidation. The danger, as the court points out, in improper consolidation lies in the fact that evidence relating to each of the crimes may have the effect of bolstering the proof of the other. That's what the court is trying to tip the scales and not make sure that the scales don't get tipped in the direction of too much prejudice. Again, this is the defense asking, and I appreciate the state's concern for Mr. Burgess's well-being and to have effective assistance of counsel. I can assure the court and Mr. Burgess that I'm providing effective assistance of counsel. This is in his best interest, and he understands that. He also joins in the request, meaning that a 3.850 motion would fail on the merits if he tried to invoke the court's jurisdiction based upon this particular issue. We are both in agreement that we're doing this. I'll end with this fact from Crossley. The court pointed out that no facts justify the consolidation. However, on page, well, it's hard to say what page. Anyways, in the instant case, both robberies were committed within a few hours of each other, only a few miles apart. However, the two episodes were entirely independent. Unlike Livingston versus State, here there was absolutely nothing to connect one crime with the other. Well, we have a reason to connect the crimes with one another here, and that is that they're causally related. As the Ellis case points out, a causal relation justifies a consolidation if it's useful. And I don't believe the state has exhibited any prejudice to their case that would tip the scales back towards having the cases heard independently. So I'm asking the court to join the cases. Thank you.
Anything else, Ms. Wilson?
Just again, Your Honor, the length of the trial and the codified state that there is prejudicial, and then I think that the definition that they give in here to show that it has to be related, and the facts in this case that possibly didn't, match up and did not become the same act. There's nothing in the rule, Your Honor, that indicates, or any case law that indicates that the causal connection or is the defense that would qualify to actually consolidate the case. So I argue that it would not be allowable under the law.
And I rebut that with the fact that, as I said from the outset, there's a dearth of case law on this issue because the issues may not get to the appeals courts. The state doesn't have a right to appeal if the defendant is convicted. And if the defendant is acquitted, there be no appeal. So there can hardly be any case law on this particular issue. But I don't like the fact the state is arguing, well, these rules are made for the state. In other words, if the defense has a good point of view and why under Williams' rule, and I'm not saying this is Williams' rule evidence, but intent is one of those guiding factors that we can consolidate offenses or bring in Williams' rule evidence. Well, the intent of Mr. Burgess is the issue here. And the intent makes it causally related. These rules aren't geared for the state. They're geared for both sides, to be fair. And we're asserting that the fairness in this case would be to consolidate the three offenses so that one jury can figure out whether Mr. Burgess was really insane or not insane. Thank you.
Rule 3.151 sub B provides that two or more informations charging, quote, related offenses can be consolidated for trial. The first part of the rule describes related offenses if they're triable in the same court and are based on the same act or transaction or on two or more connected acts or transactions. It's my recollection that at an earlier stage of this case, Dr. McMurray opined that Mr. Burgess had undergone a continuing psychotic episode from all of the events in the three cases. There certainly would be some judicial economy, even though the trial might be a little longer. It's certainly going to be not nearly as long as if we have three different juries with three different experts testifying on three different occasions. I tend to agree with Mr. Harris that the rules do cut both ways. Most of the cases cited by the state are where the state sought consolidation and the state simply was able to prove, or the concern was the state could prove one case because bringing in other cases would tend to imply guilt on each case. Here, Mr. Burgess has conferred with counsel. He agrees with the decision of counsel, and they are connected because they are temporally related. For sure, the first two is within an hour of each other. They all share the bizarre behaviors, including the one at the jail that came 3 days later. And they all involve the same mental health defense. And whether or not Mr. Burgess was able to appreciate, under the legal definition of insanity, whether his conduct was in violation of law or understood the consequence of his behavior, et cetera, we'll have to tailor that to the exact requirements of the insanity defense. But basically his mental health at all three times, which are certainly for the first two cases very close in time with very bizarre behaviors. We have an expert for the defense that's already opined that all three are the product of a temporary psychotic episode. And even the one at the jail involves also odd behaviors. So I don't see unfair prejudice to the state. If anything, it might actually, potentially increase their chances for conviction, but the defense believes it also can weigh in behalf of the defense in terms of the jury understanding that one defense applies throughout. I don't think the jury will be confused. I think that counsel in their opening statements can make clear that there are three different events, but that they are temporally related, and that the state will have to prove beyond a reasonable doubt each element in each case, but the defense will have an overriding defense involving all three. I think the state and the public are better served by having a reduction of expense. And at this point, I will grant the defense motion for consolidation.
I will provide an order, Judge. I'll send it by Ms. Wilson.
Any other clarifications?
No, sir. I think we have also.
We do have Ms. Fuentes here. I apologize for keeping you, Ms. Fuentes, just the way things unfolded. we do need to have case management on this case.
Yes.
Do we currently, Ms. Fuentes, have a new court, another court date set at this point?
There's nothing that, you know, you're going to need to set another case management, the court just, trying to order the half, it's evaluated by the state expert,
Okay.
so.
So Ms. Wilson is suggesting a potentially final case manager, Mr. Harris, so that we can have the evaluation with Mr. Burgess's cooperation, and from that date be able to set a trial cycle, I think.
Yes.
And by the way, I do think that I'm optimistic that the restrictions on the amount of trial time available are going to be opening up if things continue positively. So hopefully at the next case management, we can see where we have enough days depending on what's estimated to be involved. Ms. Wilson, when do you think that we would be in a position to address this based on what the experts need to do, any reports, and the state's evaluation of that?
I would think, we probably should go out at least a couple months, make sure we get things.
So it suggested, Mr. Harris, to 60 days for the final case management. Any objection?
Is there anything closer than that?
Let me ask Ms. Fuentes, what are the next two case management dates?
July 15th at 1:30 or August 19th at 1:30.
So we have July 15 and August 19. Mr. Harris?
Why don't we see where we are July 15th? Because, I mean, once the expert makes his evaluation, whether, you know, insane or not, I think we're ready for trial at that point. So if he can get it done in the next 45 days, I would hope.
Wilson, any other comment?
Just, I note that we do have, between this time, a holiday coming up, that will also lose us some time in this, and I'm sure that we want the experts to make sure it's these types of cases, but also the stuff.
Well-
Ms. Harris would like to apply, and we're gonna go out quite a few months anyway, with the steps with all of our files.
Well, certainly we'll set the trial at an appropriate time, depending on how far along the expert is. But Mr. Burgess has been in custody for quite a while. I'll set the earlier date, the July 15 date, but from there, we'll see where we are, and we'll certainly give both sides the opportunity they need to prepare. So, but I do think we should go for the earlier date to hopefully move things along.
I hope so.
Anything else? What date and time, Ms. Fuentes? July 15, 1:30, final case management.
Right, and my office is, I'm sorry.
In county? Yeah, we need to have Mr. Harris, since you had apparently reached out to Judge Brown, who had voiced no opposition to having it brought in, if you could prepare a proposed order consolidating and bringing the case to join the July 15th case management.
I'll do that. I just want the court, Ms. Wilson, to know that my office has already prepared copies of all the discovery and relevant documents and all the experts' reports for the new doctor, and we're prepared to send that packet out today. We just got the judge's order, so we're going to send it all out.
Okay. Ms. Wilson, anything else? Mr. Burgess, you were able to hear and understand all of that? Very good. Thank you for your patience. All right, adjourned. Goodbye.